Hello, everyone, and welcome to our webinar, Take Your Business into the Future, Capital Raising Through Digital Token Offerings. So today we have the following guests. Jor Law, who is the advisor and interim co-head of issuance at tZERO. Jor manages product operations and sales for tZERO's products and services for primary issuance tokenizations. He is also a finance and securities attorney and the co-founder of VerifyInvestor.com, the dominant accredited investor verification service. And he is a consultant and advisor to Polymath and Prime Trust. We also have with us Rob Christensen, who is the vice president of product management at tZERO. In his role, Rob is responsible for tZERO's security token trading platform and the industry's first regulated security token exchange. Rob has been with tZERO since its inception in 2014. We also have Ignacio Celis-Aguirre, who is an associate with Mitchell, Silverberg, and Knapp. His practice focuses on corporate and transactional law, specializing in emerging companies and investment funds. Ignacio also provides legal counsel to early and mid-stage companies. And finally, there is me, Arina Shulga. I am a partner at Mitchell, Silverberg, and Knapp, and my practice focuses on corporate and securities law, and I represent companies from early to mid-stage, as well as token issuers and investment funds. So I will begin our webinar by first quickly introducing MSK, Mitchell, Silverberg, and Knapp. We are a full-service law firm with around about 130 attorneys and offices in Los Angeles, Washington, D.C., and New York. And we have a strong crypto practice group with kind of multidisciplinary approach that includes attorneys from corporate, securities, tax, real estate, and crowdfunding practice groups. Rob, I know that tZERO is a big brand in the space. Can you please tell us a little bit about the history of tZERO and how it got to where it is today?
Sure thing, Arina. So tZERO's journey really began with Overstock.com, which was the first major retailer to accept Bitcoin as a payment method back in 2013. Our CEO and founder of Overstock.com, Dr. Patrick Byrne, became a big Bitcoin supporter and started a project within Overstock's R&D lab to investigate other use cases for the underlying blockchain technology. Out of that project was born tZERO, which is the blockchain meets capital markets arm of Medici Ventures. And we began with a simple use case back in 2014. And that use case was, how do you issue a crypto security for a public traded company? So we began by doing a rights offering for Overstock that we issued in December of 2016. And this token was issued and traded in a secondary market utilizing Pro Securities ATS. Since that time, we've been working on scaling and expanding that platform. And over the course of 2018, tZERO was able to do its own security token offering. That offering was closed in August of 2018, and we issued our security tokens in October of 2018. During this time, we developed a new security token trading platform, which covers issuance, trading, settlement, and the reporting aspects required in a regulated environment for this new asset class in security tokens. That platform went live January 10th of 2019, and that pretty much brings us to date in terms of milestones and how we got here today.
Well, thank you so much. A lot has been done, right, in a very quick amount of time. So sometimes people ask me whether anyone can use a security token offering just to raise capital, or do tokens actually need to have a utility component? And here, I think that it's not necessary for the tokens to have any utility aspects if you are issuing them for the purpose of raising capital only. But I think it's also important to understand why you actually want to issue the tokens. Is it because you need customers to use the tokens to access and interact with the platform? Or is it because you want to raise capital, right? If it's the former, then, and if you are done with building your platform, then it is possible, right? It's possible that what you're issuing are actually utility tokens. So my analogy here is like a laundromat. I always think of laundromat tokens, without which the laundry machines won't work. So if that's the type of token that you're issuing and your machines or your platform is fully built, then there is an argument here that what you have is a utility token that's outside of the securities laws. But I would actually caution you and advise you to consult with an attorney, right, before fully concluding that that's the case. So, Ignacio, what is the difference between an initial coin offering and the security token offering?
So originally, I would have argued that STOs could have been folded into ICOs, so security token offering into initial coin offering. Out of the maybe 22 billion raised by ICOs, about 650 has been raised by compliant STOs. But as there's been more regulation in the crypto space, STOs have rightfully taken on a life of their own. So in a normal ICO, as far as an ICO can be normal, a method, they exchange funds for digital coins or tokens, and usually you had speculative investors and early supporters of the projects. And a lot of these ICOs were done in an unregulated environment, and because there was no collateral behind the tokens, there was many instances of fraud. I think somewhere about 92% of ICOs were at least accused of being fraudulent. STOs, on the other hand, are a method of fundraising very similar to the ICO in that they allow investors to buy digital coins or tokens as a part of the offering. However, unlike the ICOs, the STOs have embraced the regulatory aspect of it. And more importantly, the digital coins and tokens purchased in the offering are tied to underlying tangible assets or profits or shares of the issuer. In other words, a security token represents a right to some of those tangible assets or shares of interest. It is a formally digitalized security, and as ICOs have become less common, we're seeing more and more companies turn to STOs to meet their capital needs.
Great, thank you for that. And Jor, what are the common terms you see in security token offerings?
I think actually the common thing is that there is nothing that's really common. We have seen deals, hundreds of deals kind of come across the tZERO kind of sales team, and they varied from, real estate deals to oil and gas deals to tech startups to blockchain to funds, etc. And as you can imagine, each one of them has dramatically different terms. And this was actually a challenge for tZERO and its subsidiaries as we started thinking about what sort of fit in, what sort of criteria would we want as a company associated with our brand. What sort of criteria did Pro Securities want as associated with their brand? So, Rob and I and others on the tZERO team took months kind of coming up with trading qualifications, issuance qualifications, and then we modified them, and we're probably going to continue to modify them based on kind of feedback we get from the industry. I think that when you think about tokenization, some of the trends that we see, I think that kind of highlight what common terms are. I think you could think about it in three different ways, right? First off is tokenization by itself doesn't necessarily change underlying finance, right, and economics, right? So the investment deal and investment terms, you get a large number of deals that have effectively the same type of structure and same type of deal terms that you normally would have in real life, even without tokenization. Another kind of a point to think about is that because tokenization had elements of crowdfunding, because it had elements of, hey, we're going after kind of non-institutional investors as well as institutional investors, perhaps we can get away with doing a product that has slightly lower yield, right? Like if you were doing a privately funded deal only with institutionals, you might have a slightly better return for the institutions than you might do otherwise with the crowd, right? One of the reasons you might tokenize is that you might try to shave off a point or two and bring the deal economics away from the investors toward kind of other parties of the deal. So you've got a group of deals that are coming in that seem to mirror real life scenarios, but they're more akin to crowdfunding, where you saw that the yield was just a little bit, worse because people are trying to take advantage of the better economics of kind of going out to the crowd, right? And then the last one is just the set of deals that have really unique structures that, not that you couldn't see them in real life, but you haven't thought about them, right? And traditional financing was equity, something like that, right? In tokenization, a lot of these things were just profit participations. They were royalty shares. Some of them were tied to elements that wouldn't necessarily be tied to any one event. So, for example, someone once brought up the idea of, well, what if I paid you a token that was a percentage of however many miles, navigated plus the weight of a shipping container, right? So that's something that you could duplicate through contract, but if the concept of tokenization and what other people have done in the tokenization concept has caused people to think a little bit more creatively. So we've been seeing some of those deals come through. The trick, of course, with all the STOs are to kind of figure out what's a great deal and what's not.
Interesting. Okay, so Ignacio, what and I know there are many laws, right, that we need to consider, and here I'm talking about just the US laws, but what securities laws or rules or regulations or exemptions we need to be aware of when contemplating or structuring a security token offering?
Got it. So unless you're registering the offering of securities under the Securities Act, you have to rely upon an exemption or an exclusion from the Act to sell the security tokens. And like you mentioned, there are several different exemptions or exclusions, but I'm going to touch upon like 5 of them for now. First off, there's regulation CF. Reg CF is a limited offering done online through a registered crowdfunding portal. It's one of the newer ways to raise capital. In Reg CF, investors do not have to be accredited, but the amount raised is limited to $1.07 million a year. And unfortunately, for some issuers, only US companies are eligible to conduct a Reg CF offering. And then you have more traditional ones like Reg D. That's where rules 506B and C come from. Reg D can be used to sell to both US and non-US investors, but requires investors to be accredited in the case of 506C, or in the case of 506B, you can have a small number of sophisticated investors or representatives that would make them sophisticated. You can also have Reg S. Reg S is an exclusion. It governs the sales to non-US persons in offshore transactions. It's possible to conduct a domestic private placement, such as under Reg D, simultaneously with a Reg S. That way you can have the largest amount of investors possible. However, such bifurcated offerings need to be carefully structured. If not, you risk getting them integrated and then violating securities laws. Lastly, one of the newer ones is also Reg A+. Some people consider it the mini IPO because you file a registration statement similar to an S1 used in a public offering. It needs to be submitted, reviewed, and approved by the SEC. You can have 2 tiers of fundraising. One is 20 million and one is 50 million. They're both capped at a year. So that's the amount you can raise in that year. And in both cases, like Reg CF, you can raise money from non-accredited investors. And I think the tier 2 limits what they can invest based on their net worth. However, there's a lot of problems with Reg A Plus. Standard security offerings have had a lot of issues and not a lot of success with the Reg A Plus. And then in the digital asset space, I don't think we're aware of a single successful Reg A Plus offering. So the SEC has yet to approve any of them, but that hasn't stopped companies from trying. Just earlier this month, Blockstack, I believe, filed a Reg A Plus with the SEC. They're going to do a tier 2 offering for investment contracts up to 50 million. And I think they estimate their legal fees to be 1.5 million. Reg A Plus is also limited to the fact that only US and Canadian companies can use it. But as far as the digital, like kind of secured token offerings are involved, Reg A Plus has not proven to be a successful way to raise capital.
Yeah, we can add some color to this as well.
Yeah.
You know, the deals that have come through the tZERO pipeline have largely been Reg D, Reg S. We've seen almost no Reg CF, or at least if they're kind of doing the CF, they're not coming to us for the CF portion of it. So definitely a lot has been Reg D, Reg S, followed by registered offerings and Reg A pluses. And so we've seen a number of people who are going through the registration process now, or have already filed, or are going through the Reg A plus process now. And while it's true that none of them have really yet been approved, there are a number of people that think that they're reasonably close. And the expectation would be that, of course, if the SEC does approve one or a handful of them, they probably would have no reason to withhold many of the other ones. And if you look at kind of the non-tokenized Reg A pluses that were approved to go on, they haven't exactly been the most impressive issuances, perhaps. So holding it up just for tokenization, once you get past that hurdle, I think you're not going to have other artificial barriers to entry from a qualification perspective.
Yeah, and the only thing I would add there too, I think the reason we're seeing the trend, the Jobs Act, which introduced Reg A plus, I think it did a good job in terms of lowering the bar of entry for investors, allowing companies to raise from, retail investors or non-accredited investors. But I think where the Jobs Act has fallen short is it really doesn't lower the bar for companies to issue. All of the overhead of being a publicly traded company, you're going to be required to do under Reg A plus, with the capping of the amount of capital you can raise. So most companies we speak to that are looking at Reg A or Reg A plus, once they kind of realize the ongoing requirements for that company, quarterly financial reporting, et cetera, most of them revert back to Reg D and Reg S because they have no cap on the amount of capital they can raise, and the overhead ongoing for the company is lower. So I think, legislation to help lower the bar to entry for issuers, you'll see more people move into the Reg A plus type offerings, and you'll see greater success there.
Yeah, and this follows kind of what we saw in crowdfunding, where Reg CF and Reg A plus weren't nearly used as much as Reg D was. If they increase Reg CF to $5 to $10 million, if they increase Reg A plus to $150 million or something like that, I think you'd see a much larger use of it. But to Rob's point, when 50 million is all you can raise and you've got all these hurdles, it's more money. It's still worth considering, but it's there becomes really a cost benefit analysis to it.
No, I absolutely agree with you, and I hear that a lot from other people in the legal industry as well. So now I would like to briefly talk about the new developments in the digital token legal field, right? And there are actually four things that come to mind that just kind of occurred. So first is that there is the Token Taxonomy Act of 2019 that was reintroduced and is now undergoing review. So that act was originally introduced and now reintroduced by Representative Warren Davidson from Ohio. And that act aims to ensure that a digital token is not a security, such as a stock or a bond, so would not be regulated by the SEC. So in addition to that, the Act wants to direct the SEC to issue certain regulations regarding that, also wants to adjust taxation of virtual currencies held in individual retirement accounts, and also wants to create a tax exemption for exchanges of one virtual currency for another. And from what I understand, this Token Taxonomy Act enjoys broad bipartisan support. Separately, there's another act that's called the Digital Taxonomy Act of 2019, which was introduced by Congressman Soto from Florida. And that one is more about consumer protection and aims to give the FTC, Federal Trade Commission, an additional $25 million in funding to combat unfair or deceptive practices involving cryptocurrencies. So in addition to that, on April 3rd, the Securities and Exchange Commission issued a guidance titled Framework for Investment Contract Analysis of Digital Assets. The framework lays out a helpful guidance identifying factors that market participants should consider in assessing whether their digital token that they want to offer and sell would be an investment contract and therefore a security. So an investment contract is a security and therefore is governed by securities laws if so basically the definition of an investment contract comes to us from the Howey case. That's a U.S. Supreme Court case back in 1943, I think, where the investors invested their money in a common enterprise with an expectation of profits to be derived solely from the efforts of the others, meaning of the promoters or the sponsors of that kind of project. And if a token fits the definition of an investment contract, the token is a security and therefore security laws apply. So the framework lays out helpful guidance regarding whether or not a token would be deemed to be a security. However, that framework has not been, and that's what they say, a quote, has not been approved or disapproved by the SEC and is therefore an informal guidance of several of the SEC staff members, which, although is very helpful, right, may not and should not probably be construed as the official position of the entire SEC. So, and the fourth kind of development I want to mention is that the SEC on the same day, April 3rd, granted the first ever no action letter, no action relief to Turnkey Jet. So no action relief means that the SEC will not take an enforcement action against Turnkey Jet if they were to implement the described scheme. So they described what they wanted to do in a request to the SEC, and they essentially they run kind of like an air shuttle, air taxi type of service, right? And they want to issue digital tokens that can be purchased by those who would then later pay with those tokens for the services. So, but here we need to remember that the no action letter is actually kind of personal in the sense that it is enforceable only with respect to the particular entity that requested it, and also only with respect to the particular set of circumstances that were described in the no action request. So others may rely on it in the legal sense, may not rely on it in the legal sense, although may still use it as a guidance for structuring their own utility token offerings. So this is the first time when we actually know what a utility token is or could be, right? Because all throughout, well, starting in July of 2017 and all throughout 2018, we kind of got a guidance from the SEC as to what a utility token is not, or what a security token is, right? But we never actually had the guidance, or even more than a guidance, like a no action letter, kind of describing the parameters of a utility token. It is not a big universe. It's kind of pretty narrow, right? But if you stay within these boundaries, chances are that you will, or you may have a utility token on your hands. So now let's turn to kind of a second phase of our webinar, and let's talk about the actual STO security token offering process. So Ignacio, could you describe for us briefly the stages of an STO process?
Okay, so briefly, like you said, the STO process can be broken down into three parts. First, there's the pre-STO part, and in my opinion, that's the most important part of the process. Here, company management should focus with working with lawyers to properly structure an offering that would both meet their needs, and also they need to make sure that they're going to be compliant. This means making sure that documents are in order. For example, company charters may need to be amended, and in any case, compliant offering docs need to be prepared, such as offering memorandums and subscription agreements. Also, depending on the type of offering, this is when the company would come up with a marketing plan if they're allowed to market. Next stage would be the issuance. This is the favorite part of many people. The issuance involves the KYC AML checks on investors, and depending on the type of offering you are conducting, verification that investors are accredited. This is also when the tokens would actually be issued and funds would be collected. Lastly, you have the post-issuance, and this is kind of maintaining the STO. The company here should communicate with investors, and depending on the STO, there might be items they need to take care of, like token buybacks or distributions, depending on what the terms of the offering were. Importantly, the company should also make sure that the complexities of the secondary trading of the company's securities are being managed, and these are things like lockups and caps on the amounts of investors that are holding the security tokens.
Okay, thank you. So Rob, how does tZERO's tokenization technology actually work? Can you walk us through that, please?
Sure. So when it comes to tokenization, we really enter the picture in what Ignacio described as the issuance phase. Once you've collected all of your investors' data, you've run your KYC, AML, OFAC, bad actor checks, and accreditation verification, we take all of this information and we enter into a whitelisting process where the mapping of investor data to their PII information occurs so that we can verify that the wallet held by this investor does in fact belong to this investor. And we whitelist them into tZERO's global registry of investors. Now, the metadata we collect and store on chain around these investors does not include the PII. What it does include are facts, such as their accredited investor status, that they are in good standing as far as KYC, AML, and OFAC checks are concerned. It stores domicile, so we know that address maps to a US-based investor or a non-US-based investor, maps to specific jurisdictions around the globe. And it also holds, basically what's a timer, right? So it'll keep track of their accreditation status, and based on the means by which they provided evidence of their accredited investor status, this could be based on income, it could be based on liquid net capital, it could be based on a few other factors. such as sophistication level, et cetera. But each one of these validations carries with it an expiration date where it requires that investor to recertify. So the contract will keep track of when an accredited investor is due to re-verify. And we do this so that different compliance rules can be enforced. So on the blockchain, all of the compliance rules that are enforced, they really pivot off of these metadata elements in the global registry. These facts we know about the blockchain address and the investor that owns it. So that's the first step of the tokenization process. The second step is the actual issuance of the asset itself. This is a separate smart contract. And when we deploy this, we take what is essentially going to become the cap table for that company, and we issue a number of securities. For example, if you're issuing 1 million security tokens, we will mint those tokens. We'll mint those tokens on the Ethereum network. tZERO, all of our smart contract technology, all of our ledger technology is currently Ethereum based. And we will mint all those tokens and we'll go through an allocation process. Now, the allocation process is as follows. We will typically issue the total supply of tokens or the total amount of securities into a wallet and into an address held by that issuer. And we call this the Genesis event. And it's basically the creation of that asset on the blockchain. And then through the allocation process, we will distribute a quantity of tokens to each investor, depending on, what percentage or what number they invested in. So this is very similar to the allocation process followed in, traditional capital markets. So if this is a registered security and a publicly traded company working with a transfer agent, our platform will receive instruction from the transfer agent in the form of an allocation file or allocation instructions for us to distribute a number of shares to each investor in that list, in that cap table. So once the actual assets have been issued and tokens have been minted and distributed, it really depends on the asset and the registration or the exemption that they have been issued under. For most issuers that we see at tZERO that are doing it under Reg D and Reg S, you enter into a lockup period for the Reg D tokens, which lasts 365 days. Reg S, there is no lockup requirement, so they can trade almost immediately. Or resell those private securities almost immediately. And again, our compliance interface and the compliance rules based on the asset, what stage in the life cycle of that asset it is in, whether it's in lockup or after 365 days has expired, it's now freely tradable. Based on the time the asset has been issued and held by the investors, and based on the exemption or registration that it was issued under, the compliance rules will enforce all applicable rules in terms of the transfer of registered and legal ownership of those securities as a result of resell or of secondary trading. Now, that kind of covers the ecosystem. In terms of the technology, as again, Ethereum-based smart contract technology started with ERC-20. That's what the lion's share of ICOs done over the course of 2017 were done on. And it's really a token standard that allows for wallet interoperability, which means a lot of web-based or hardware-based wallets can hold the tokens if you conform to this standard. What we've seen in the industry now is because we're moving away from ICOs that we saw in 2017, and there's an appetite for this to all be in a regulated environment in the form of an STO. We've added functionality on top of ERC-20. We do want to preserve the backwards compatibility so that investors have a lot of options in terms of the wallet technology they utilize to hold these securities and these tokens. But we've had to add additional features, including, the whitelisting capabilities, right? How do you prevent bad actors from holding the tokens? How do you ensure that the good actors that currently hold tokens remain good? So all of the whitelisting and investor management functions, as well as all of the compliance rules in terms of timing and how those securities can be held and transferred, have all been written as extensions on top of ERC20. We do have our own token standard at tZERO. It is an open source token standard, and we can distribute more information about it as a follow-up to this webinar. But that really kind of covers the step-by-step process and kind of the base technology around our tokenization process.
Okay, great. This is very helpful. So, Jor, in your opinion, is there a particular industry that is more kind of is like a better candidate to issue security tokens? Is there any type of company issuer, any type, that is best suited for that, or does it really work for anyone?
If you think about it, tokenization is just a technology, right, that kind of makes securities more efficient. So to that extent, it's theoretically all companies that could benefit from tokenization should benefit from tokenization. Now, it is still considered alternative finance, much like crowdfunding or EB5 was considered alternative finance, and as such, you will tend to get certain classes of deals that might be early adopters. You saw, and you're already seeing that real estate is one of the big industries that's looking at tokenization. Many of the deals that have been announced or are being worked on are tokenization or real estate projects. Certainly, the projects that are blockchain related, they are a natural fit for tokenization. They're already playing in that ecosystem. They appeal to people in that ecosystem. So for them to raise money from people that are already in the ecosystem makes sense. But honestly, you've seen people kind of across the board. Some of the more kind of boring, old school manufacturing, and operations type businesses maybe will be kind of later to come on. Those people will be kind of more mature before they come on. But really, you're starting to see all types of deals come on, including institutional grade debt deals, that are sometimes tied to real estate, sometimes not tied to real estate. But to be fair, I think you've seen it as well at your law firm, where you're seeing blockchain companies, real estate companies, and technology companies kind of being first movers in the space. One interesting area was when crowdfunding was around. One kind of sector that really kind of went toward crowdfunding were the people in kind of like alcoholic beverages or cannabis. And I think so we've seen a number of cannabis related companies explore tokenization. Less so on kind of the breweries and the people in the alcohol business, but I wouldn't be surprised if those types of industries are early adopters as well.
Interesting. Okay, wonderful. So now I briefly want to talk about what type of investors you should, look for, right? And also whether or not you can and how you can market this, offerings. So first of all, about the investors. So all investors, to me, are generally divided into two categories, right? We have accredited investors and non-accredited investors. Accredited investors are those that, whom, and I'm talking about individuals here, right? Those who make over 200,000 a year or $300,000 a year together with a spouse, or have over $1 million in assets, excluding the value of primary residence. So depending on which exemption or which rule you comply with, only certain type of investors can participate. And we've already kind of discussed that a little bit. So if you are conducting your STO pursuant to Rule 506B of Regulation D, you can offer your tokens to an unlimited number of accredited investors, but also to up to 35 non-accredited investors who are financially sophisticated. However, it is actually unlikely that you would be using this exemption just because it doesn't allow for general solicitation and advertising to be used. Whereas in an STO, you're more likely to want to reach out to as many people as you can. So next, there is Rule 506C, right, offering, and that's, I believe, the one that's most commonly used nowadays. There you can sell your tokens to accredited investors only, and the issuer actually has to take reasonable steps to verify that all purchasers of tokens are accredited. So the burden is on the issuer. But then you can, there's no restriction on general solicitation and advertising. In the Regulation CF offering, and I'm not surprised that the tZERO team has not seen many because they can only be conducted through a registered crowdfunding portal. Investors do not have to be accredited, right? But there are limits as to how much they can invest based on their annual income or net worth. And then finally, if you think about the Reg A Plus offering in a Tier 1, there are no restrictions. Anyone can invest. In a Tier 2, again, non-accredited investors are allowed, but can invest only up to 10% of either their annual income and net worth. And there are two more kind of numbers that I'd like you to remember. So, okay, so in order for an issuer, for a company to not have to register a class of equity securities with the Securities and Exchange Commission under the Exchange Act, it cannot have more than 2,000 persons who are shareholders of record, or with respect to that particular class of equity securities. Okay, so no more than 2,000. And the second number I'd like you to remember is that if you are tokenizing a fund, right, and you are complying with this exemption called Rule 3C1 exemption from registration under the Investment Company Act, then you can only have up to 100 beneficial holders. So it's actually important to think about these limitations in advance while you're still planning your STO, so as not to accidentally trump that. And then briefly about marketing and STO. So again, marketing efforts will depend on which exemption you're using. So no advertising or solicitation for Rule 506B offerings. Definitely yes for 506C offerings. In the Regulation CF offering, issuers can only communicate and market through the portal. Right, they would have a page on the portal, and but can only market through that portal that they're using. And with respect to Reg A Plus offering, generally yes, it's permissible to use advertising and solicitation and marketing, but there are limits, right? There are limitations that exist depending on whether you're just testing the waters and you have not been qualified yet, or whether you have the the offering has been approved by the SEC. So there again, okay to do it, but then there are limitations as to how you can do it and what type of information you have to provide to those you solicit. Okay, so Jor, in your opinion, is it possible to kind of like go ahead and do this STO and generate digital tokens if you don't have any technical or programming skills?
Yeah, definitely. When you think about how finance is done today, a lot of business owners are focused on their business. And when they go to do a capital raise, they go and hire professional advisors to prepare the PPM and things like that. They help in to get feedback, but other people are effectively helping them create these. And that's the same with token design, right? Certainly, if you wanted to do it yourself, as people have done in the past, they could go hire developers and have developers go and program it, and they could require technical talent. But these days, you have your option of choosing from kind of do-it-yourself providers like Polymath, or you can go to someone like tZERO and have tZERO do the tokenization for you, and you tell tZERO, like, these are the elements and features that we need. I need this rule set. I cannot have more than, I need to monitor for more than 2,000 holders or more than 100 holders, etc. And the tokenization team of tZERO can effectively create that token for you. So do you really need technical skills to do that? No. Is it helpful to kind of have a little bit of technical background in terms of managing things? That would be great. Once you have these tokens, of course, you've got to manage them over their lifetime. And even though you can hire out a team to do those for you, and also tools that will help you manage it will be relatively easy. So if you can use a browser and use a tool like Carta, which handles effectively digital certificates. If you can use that type of tool, then in the future you should be able to manage your tokens just as easily as well. Rob, do you have anything to add to that?
No, I think you hit on it fairly well. And the real message here is companies don't need to go out and hire their own blockchain developers to do this. They don't need to have any real subject matter expertise in tokenization, blockchain, wallet management, private key management, and storage. There's a lot of great firms out there now that are providing this as a service and really streamline the process for companies looking to issue this type of asset. Certainly more so than in 2017 or even as recently as 2018. The pace at which the technology and the industry is moving forward, kind of pushing into this digital space and tokenized securities is moving at the speed of light. So I would encourage any issuers, not to be intimidated by the technology factor. There's so many ways to have that done in kind of a chauffeur-driven method at this point, where you can really just engage someone like a tZERO, a Polymath, a Securitize to do that type of process and tokenization for you.
Okay, thank you. So before we move to the third part of our webinar, where we'll talk about trading and the post-STO kind of environment, Jor, is there anything else that you would like to tell us about the primary issuance business or at tZERO?
Yeah, a lot of people kind of view tZERO as a company that kind of focuses on secondary trading. And to be clear, the secondary trading is software that tZERO creates, but the business for secondary trading is run through kind of licensed affiliates or subsidiaries of tZERO. But tZERO is actually a technology company with much more than just secondary trading. And one of the things it does have is a primary issuance business. And this is the business that helps someone that wants to tokenize, even if they might not be trading. That's a business line of the primary issuance team. Things like providing technology for a funding platform, possibly for the right deal, possibly coming onto a tZERO branded platform, coming onto a platform that we may launch in the future, things like that, right? So consulting around some of these services. So these are all kind of services that the tZERO primary issuance team can do. And the genesis of this effectively was that while tZERO's very interested in working with other partners and providers in the space, we have had a fair amount of people that came to us directly that just said, hey, we just want to work with you. We believe in your vision. We followed Patrick Byrne for many years. You guys have done this already. We know ultimately we want to trade on pro securities. Can you just help us, from start to finish without making us go somewhere else? So, I think that was the genesis of the primary issuance group. And it's just a capability that we have to kind of assist a few select issuers that we think could use some of our extra help.
Yeah, I actually think it's very helpful to just be able to come to one place, let's say an issuer, right? The company is thinking about it, but not really sure. First, they don't have the technical expertise. They don't really know what the terms should look like, right? But they're interested in exploring this type of capital raise. They can come to you. They can engage a firm like ours, for example, and then together we kind of figure out the terms. Your consulting would be very valuable here, right? And the expertise and the experience that you already have in the space. And then you can just implement it through, the actual token issuance on, on tZERO. So that's
Yeah.
definitely helpful.
Yeah, I think just tZERO has certain kind of advantages in the marketplace in a sense that they were early adopters. They did the Overstock token, they did the tZERO token. They've talked to the SEC, they've talked to FINRA, they've built out their own technology for exchange, they built out their own technology for a number of things. You don't get many companies where you have someone like Rob who's worked on kind of negotiating with lawyers, to help structure their own capital raise, to actually affect and kind of execute successfully their own STO more than once, and to help others with theirs, and then to build a technology that underlies the entire infrastructure. So tZERO is really interesting in that they're not just consultants that advise you on how you might be able to do it. They've actually gone through the process themselves successfully, and I think that provides a level of experience and insight that many other companies don't have.
Absolutely, I agree. So now let's kind of move into the third and the final stage phase of our webinar and talk about trading. So, let's assume that the tokens have already been issued. So what's next? So, and the first question that comes up, and it actually comes up a lot, is can investors resell their tokens? How soon after the issuance can they resell? What are the restrictions, right? So from my perspective, right, generally tokens that are sold in private placements, right, they are restricted tokens, they're restricted securities, and cannot be just freely resold. And most of the resales are done in reliance on Rule 144, right? And if the issuer is not a reporting company and the seller is not an affiliate of the issuer, the seller can freely resell the restricted security tokens after holding them for at least 1 year. So, and that's, I'm talking about tokens that were issued under US laws. As Rob mentioned earlier, outside of the US, those tokens that were originally issued pursuant to Regulation S, with respect to those tokens, resales are permitted, but only in offshore transactions without directed selling efforts into the US. I also happen to know that there are other ways how peer-to-peer kind of transfers can occur during the year, kind of with a shorter period. But there we're not talking about just free resale to everyone, right? Those are limited one type of kind of private resales to accredited investors. There is a section 4(1.5) so-called exemption, right, for resales, but there the seller would have to provide the purchaser with information about the issuer, and would probably still have to hold token for at least 6 months. I'm also aware of section 4(a)(7) of the Securities Act type of exemption that is relatively new. And like the previous exemption 4(1.5) that I mentioned, also requires all purchasers to be accredited investors, that there would be no general solicitation or advertising, that and that the seller needs to deliver certain information about the issuer, which is a problem, if the issuer is a private company, and that includes actually the financial statements. So that there is definitely a challenge there. But in that case, if if Section 487 is satisfied, then the securities can be resold after 90-day holding period. But as I understand, and please confirm what you're saying, that most often it's the 1 year restriction that's used. Jor, what do you think?
That's the one that everyone focuses on and has focused on simply because it's been the easy one. It's been a one that opens it up to the non-accredited investors as well. The reality of it is, of course, as you said, to the extent that securities are restricted, any exemption that lifts the restrictions would work, whether it's for A7, for 1.5, Rule 904, Reg S, or Rule 144, or anything else would work. Understand kind of tZERO technology, understand kind of where tZERO and Pro Securities play in this space. Certainly, we have seen what other people can do. We can comment on what other people can do, but largely we affect the rules that issuers and their counsel kind of come to us and say, hey, we have this token. We want to enable trading, for this rule set. Can you build out this rule set? And, I think unless we thought something was like dramatically wrong, we would effectively kind of evaluate that. That's more Rob's department. Rob, am I misstating anything there?
No, that's accurate, Joe.
Mm-hmm. Okay, excellent. And now, Rob, I have a big important question for you about the secondary trading options. So what sort of secondary trading options are available within the tZERO ecosystem? And how does the actual process work? How does the onboarding work? And then can anyone, for example, who just issued the tokens through the tZERO primary, token issuance platform, then just go ahead and list? Or is it a separate kind of process? Can you talk about that, please?
Yeah, absolutely. So, this is one area where tZERO is unique in the blockchain space. So there's a lot of people trading or applying for SEC approval to trade tokenized assets on an ATS. Now, we have our own ATS, which is Pro Securities ATS, and it's operating and trading today for the Overstock token as well as the tZERO token. We're planning on bringing several more of those on for secondary trading in the near future. But tZERO is somewhat unique in that we also are members of a joint venture with the Boston Options Exchange. And we are currently in negotiation with regulators to launch the first national security token exchange. And there's some pretty important differences between an exchange and an ATS, right? So an exchange will be able to list registered securities. It'll be able to function as a primary listing exchange. And because it is plugged into the national market system, the SEC does have an obligation to work with us on what the specific trading rules are around this new asset class of security tokens. So this is a real, advantage, and will be groundbreaking as we launch the exchange, because what it'll do is it'll facilitate the entrance of large companies, large publicly traded companies, to issue security tokens, and in the future potentially tokenize their existing traditional securities cap tables as well, and have a venue to trade on. It's also having an exchange of that size, which is much larger than an ATS, will allow for more institutional type investors to enter the market, the types of institutions that are purchasing large blocks, right, of securities. So for us, we'll always have kind of that dual path of secondary liquidity with a national security token exchange through our joint venture, and then also through our ATS for, private security tokens, as well as we can trade a public token in an ATS, but we see those types of listings, companies issuing under S1 filing, Reg A, Reg A plus. We see those types of assets naturally migrating onto the Boston Security Token Exchange. Now, in terms of onboarding, there is a pretty defined line of separation between a issuance or primary placement and on an exchange listing a token. So there is the separate set of qualifications that a token must go through in order to be traded in a secondary market with tZERO. So that being said, again, it's more about investor protection as well as brand alignment. We don't necessarily want to allow every token that's issued to trade, because we want to make sure that they are real companies, solid companies with a proven operating history, and are likely to succeed in the future. Because what we don't want is for the Long Island the Long Island iced tea blockchain company to list on tZERO, disappear overnight, and every investor on the tZERO platform is suddenly, just lost their entire investment. So we do a very careful diligence and qualification process on tokens that we're onboarding for secondary trading. Now, on the other side of that kind of hits on the issuer side, right? And depending on what type of asset you've issued, we have trading venues that can accommodate everything from a private equity, private debt, all the way up to, the largest publicly traded company through our joint venture with the Boston Security Token Exchange. Now, on the investor side, currently, as we hit on with Reg D, the tokens we issued for tZERO in January are still in a lockup period. So currently, the only investors that can open accounts and trade on the tZERO platform are accredited investors. Now, inside of 2019, that's going to open up to retail investors as we onboard additional tokens to trade that have already gotten out of their 1-year lockup period, and Rule 144 now applies. You can sell a private security to a non-accredited investor. Now, there are limits to how many non-accredited investors can hold that private security before it triggers reporting requirements. And as you mentioned, Ariana, there's also, depending on which exemption you're using, for example, 4A7, there's heightened disclosure requirements, including company disclosures, financial disclosures, quarterly financials. So, we do see on the tZERO platform, most of the activity today is with accredited investors only. But as we add more assets, that are in different life cycles, we'll begin onboarding retail accounts. And we've architected the system and built it to where it can manage all aspects of the assets and the investors that can trade in them, to make sure everybody stays in compliance, not only us as Pro Securities ATS, but also all of the companies that are trading there. So in terms of investors coming on, that kind of covers the individuals, right? In terms of institutional investors coming into the platform, we can also accommodate for that as well. And that basically involves an engagement between the institution and Pro Securities ATS in the form of a subscriber agreement. And then, the technology standpoint, tZERO is also unique in that we have a patent that was awarded earlier this year that gives us IP coverage for blockchain technology, on-chain wallet-to-wallet settlement of digital assets, and the backwards compatibility of that functionality into traditional market systems, specifically fixed-based market systems. So for us, we've tried to keep the bar to entry very low for traditional broker-dealers, traditional institutions, traditional trading desks that are already speaking to the national market system using a fixed protocol connection. they can use this same type of integration and a simple subscriber agreement with Pro ATS and have a very easy path and low bar to entry to start trading on the ATS. So I don't know if there's other things you wanted me to hit on there, Ariana, but that's kind of the scope of the universe in terms of trading venues, how issuers and their tokens are onboarded, and how also institutions and retail investors are onboarded.
Yeah, and I can add a little bit to, just to clarify, tZERO's technology supports kind of trading among non-accredited investors today. It's just kind of whether there's a reason to kind of turn that on or not. So Pro Securities, for the tokens that it is trading now, doesn't have that turned on because the tokens that it's trading now can't support that at the moment. When the appropriate lockup expires and they can, then, or when other tokens kind of on board that could require that rule set or any other rule set, then Pro Securities using tZERO technology would be able to accommodate that. One of the other things to note also is that tZERO has a vast network. In addition to kind of the many investors that kind of came out to tZERO's own STO, they've developed a quite a large mailing list of people that are interested either in issuing out tokens, trading out tokens, or investing in tokens. And on top of that, through its various affiliates and subsidiaries, tZERO has a fairly vast network of broker dealers, many of which have kind of already indicated that they'd like to kind of onboard to the Pro Securities ATS and provide the ATS access to their clients. So, as we all wonder where is the liquidity going to come from, where the investors are going to come from, tZERO has some kind of really nice advantages and kind of a foot forward in that regard. The one other thing I wanted to mention is, Rob gave a little bit of insight into the type of tokens or issuers that Pro Securities might be interested in seeing. A lot of the diligence that they conduct at the Pro Securities level is similar today to the diligence that the primary issuance department looks at. We've got hundreds of people that have kind of reached out kind of seeing if they could work with us. And for the moment, just because of resources and focus on quality and things like that, we've effectively prioritized the people that we think would be more likely to be traded by Pro Securities. And over time, as we develop the processes a little bit better and are a little bit more efficient, as we build out the team and gain resources, that you may see a divergence where the primary issuance team will work on primary issuances that don't necessarily aren't kind of like very Pro Securities favorite type of companies. But in the meantime, we do look at the technology to see whether the tokens are properly created. We do look at legal diligence to see if the tokens are properly structured, if they're likely to be sold in a compliant manner. We do look at the business team and the business factors to see if there is a proper fit and with kind of the tZERO brand.
Yes, of course, that makes sense. So I'm just gonna ask Ignacio, what are the pros and cons of issuing tokens to raise capital as opposed to just conducting a traditional private placement, in your opinion?
So I think during our presentation, we've touched upon a lot of these, and these advantages stem from the use of the underlying blockchain technology. Just to kind of recap, the advantages include rapid settlement, reduced transaction cost, automated compliance. I think Rob mentioned built-in transfer restrictions and KYC, AML, and other stuff like that. We also see advantages of fractional ownership, which is why I think a lot of real estate has been like kind of first movers into the space, at least with STOs, because traditionally illiquid assets such as art, real property, and collectibles can now be more easily owned by multitudes of people. Theoretically, you could also have no limitations on secondary trading hours, although you need to keep in mind legal and regulatory trading restrictions, such as Rule 144, at least when tokens were first issued. We're also going to see increased opportunities for liquidity and market depth. and this includes a reduced barrier of access to certain investor groups who otherwise would not be interested, and maybe certain deals that are just more efficient to have as an STO, as Rob and Jor mentioned, just shaving off a little bit of cost points might make a deal now viable. However, all of these advantages don't always play out. I think that because of the added costs of an STO, you might have to necessitate a higher offering floor in order to make the deal kind of make economic sense. And early movers, as they do in kind of every industry, usually face higher regulatory scrutiny and compliance expenses as regulators continue to adapt, and the same has been true in the digital space. In any case, it's important to identify if an STO is the right choice for your company, and then to secure the experience of parties who have gone through this and can help guide you through the entire process in order to make it as painless, efficient, and low cost as possible.
Yeah, and to the extent that the STO is conducted in matter of crowdfunding, I would just advise to look at the per investor fees and make sure that your investment minimums make sense. There are some reasons why you might want to have a very low one, even though you might lose money on some of them, just for the marketing purpose of it. But if you're really concerned about the per investor fees, nothing's worse than kind of having per investor fees of $100 and then having 99% of all your investors invest $150. That would be horrific. And we saw some of these mistakes being made by crowdfunding companies early on. So just be cognizant to the extent that your tokenization project includes some element of crowdfunding.
Okay, no, that's definitely a good point. Definitely. So about peer-to-peer trading, Rob, what's tZERO's support of peer-to-peer trading? That's happening now. That can happen now, right?
So the technology is certainly capable of doing it. We've opted to turn this functionality off, and Ignacio hit on it a little bit. The first guy through the wall is always subject to more scrutiny from a legal and regulatory perspective. And as U.S. regulators at the SEC and FINRA haven't given, clear guidance on how this can happen, we do have what's in, the securities laws, written. But as you guys are aware, that didn't contemplate a world where you could easily transfer ownership rights in a matter of seconds on a global distributed network. So the hurdles I see to peer-to-peer trading, not just from a legal regulatory standpoint, is going to tie into a few other areas that you need to be cognizant of before you start trying to do a peer-to-peer trade. Borders are still real. Different jurisdictions do have capital controls laws. You do have sanctioned countries. You do have, cross-border, jurisdictional concerns before you can turn on peer-to-peer. Part of the reason we architected our global investor registry the way we did, and part of the reason we track jurisdiction and domicile, is so that these types of rules can be honored. Now, we've done this in preparation for a world where peer-to-peer trading, and decentralized exchanges have some legal and regulatory guidance around them. But at the current time, we have essentially turned off the peer-to-peer functionality in our ecosystem, and it is a I'll say a strategic choice when we turn that on. The other item there that's important for an issuer to keep in mind in terms of peer-to-peer, as the issuer, especially of a private equity, right, your rights of first refusal on resales, your kind of management of your own assets and your cap tables, they become exponentially more complex in a peer-to-peer environment. A good example is if Jor holds tokens and transfers them to Arina, how does the issuer learn about Arina's details that they need to have in the cap table for their own regulatory compliance purposes, right? There's security, security concerns about storing PII or, personally identifiable information on chain, right? It is a distributed network and nodes can be running anywhere, right? So you got to be very cognizant of how, as an issuer, before you turn on peer-to-peer trading for your assets, how you're going to manage legal ownership, registered ownership of those assets over time. We've seen a few early security token issuers and a few ICO issuers already get in trouble over this for several reasons. One being they cannot track the flowback of international tokens onto U.S. soil within the 1 year lockup period. Peer-to-peer, creates a lot more issues. Now the technology is fantastic, and I think that's where it's headed. But I think we're just not quite there yet, right? I think you're going to see two things. You're going to see trading platforms such as tZERO facilitate most of the secondary market for the foreseeable future. You'll also see peer-to-peer transfers in exceptional cases, like the willing of shares in the event of a death. If I have a trust or I have a beneficiary, I will be able to transfer those, in a peer-to-peer fashion to, my beneficiary. But in terms of, me sending you Ethereum and you sending me security tokens, on chain, but away from a regulated trading volume, I think we're still a few years away from that.
Exciting. Okay, great. So, Jor, question for you. So, if someone is interested in working with you guys, what's the process for someone to begin that work?
Yeah. The easiest thing is, just contact sales@tzero.com. So sales@tzero.com. If you want to follow tZERO, follow their social media, take a look at their, open source kind of tZERO, token materials, things like that. If you just want to work with us and you don't want to kind of analyze everything, then just sales@tzero.com. Rob, do you have another email that you use for the trading, or has that been centralized through sales@tzero.com now?
It's all running through sales. Pro Securities as well. If you want to reach out directly to Pro Securities, is another avenue. But I'd say the best one is just sales@tzero.
Yeah, and just to be clear, sales@tzero.com, will funnel out the request to the other departments as necessary. So if there are any regulators on here, tZERO is funneling out requests.
Okay, great. So we've covered, some of the advantages of working with tZERO, and I want to briefly mention some of the advantages of working with MSK, from the legal side, for the legal work. And basically, the reasons are, simple. We actually have prior experience working with fully compliant security token offerings, and we also have experience conducting private placements under different exemptions, right? And also experience working with Reg A Plus transactions, as well as the initial public offerings. I mean, why not have an IPO of security tokens? There'll be one coming up soon, and we do have prior experience and great track record with public company work and registration, not just the private placements. And what I also really like about MSK here is that we do have that multidisciplinary approach, because obviously there'll be tax issues, that will come up. If it's a real estate related transactions, you need a real estate attorney there as well to pitch in, corporate securities, and might have forgotten, some areas, but definitely it's a team that covers all necessary areas. So I know we're almost running out of time, and I do have some questions from our audience, but Jor, a quick word about verifyinvestor.com, that is now tZERO's subsidiary, right? Can you tell us a little bit more about why verifyinvestor.com is an important part of tZERO's ecosystem?
Yeah, Verify Investor is actually a really interesting portfolio company of tZERO. As you know, kind of being the lawyer, when people do these STOs, they're effectively using some sort of securities exemption. Almost always, they're using a Rule 506C exemption. That's by far the largest exemption that people use. And to the extent that they're using Rule 506C exemption, the the main requirement there is to verify that your investors are indeed accredited, right? And if you're outsourcing it, it turns out that Verify Investor probably has dominant market share in that industry. So Verify Investor is a really interesting asset for tZERO because it is the one spot where if you want to do a compliant 506C, you need this sort of service, and you need to make sure it's done well. So, tZERO has this asset in its portfolio, which, enables issuers to effectively do this. It's the primary pain point in all sorts of Rule 506C crowdfunding or Rule 506C tokenization. And it's something that Verify Investor does well. We've done it far more than kind of anyone else has done it. We've got a global kind of base. So most of the users are domestic, but they're also international. They include not just kind of the mom and pops, everyday people like you and me, but they include sovereign wealth funds, institutions, etc. And just tens of thousands of accredited investors actively investing. And this is a portfolio company that makes that entire process just a little bit smoother.
Yeah, well, I knew about verifyinvestor.com even before I met you, because I was already recommending that to our clients. Because with Rule 506C offering, I mean, just like a single instant of a sale to a non-accredited investor can just pretty much throw out like the entire offering, right? Because there is no fallback rule that can be used. So now we have a number of questions, and one of them is for, definitely tZERO team. So here it is. Regulatory approvals required before secondary trading may begin on tZERO's ATS platform. Specifically, is tZERO or its broker-dealer awaiting FINRA approval before secondary trading may begin? And are there state securities laws restrictions on secondary trading on tZERO platform?
Right. So, for us, the regulator conversation is going on constantly, right? One of our company ethos is to keep the regulators well informed on everything we're doing. So these conversations started in 2015 and they continue today. Now, in terms of needing approval to trade in a secondary market, we are currently trading in a secondary market for our own token, and we are working with FINRA as well as the SEC to keep them informed of new tokens as they are being onboarded and trading in our secondary markets. But in terms of a formal approval or a big rubber stamp for secondary trading to go live, that's really not the case, and that's not really how the regulators work. It's more of a conversation. They ask questions, we respond. That list of questions gets shorter with each turn, and each conversation with them. And then we mutually agree to move forward, right? But there is no like definitive date or, stamp of approval that we're going to get from a regulator. That conversation is open-ended. However, in terms of trading, for secondary markets, we will be able to onboard additional tokens for trading as long as they're within material compliance with securities laws. The issuance was done under the right exemptions or registrations, and the company is a good actor and not in any kind of bad standing with regulators. We can onboard those and trade those within U.S. law. So
Okay, well,
anything you
thank
want to add to that, Jordan?
Okay.
Yeah, the SEC does have some resources on ATS, so you could kind of go through the website and kind of understand kind of what it means to be an ATS and how it gets formed and what deemed effective means and things like that. One of the other questions was I think how do we enforce kind of the trading restrictions or something like that, and again just understand that tZERO is a technology kind of provider, Pro Securities is ATS, but the first step would be that the issuer or the issuer's counsel would kind of dictate the terms of what they thought could be their secondary trading. Now, Pro Securities may have additional criteria on top of that, but that would be separate from what kind of the legal requirements would be, or what the issuer and their counsel decided.
Okay, great. Let's quickly run through other questions. I have heard that once the Reg D tokens clear their restriction period, they can be resold to anyone, even non-accredited. Is this true? The answer is yes. Okay. I don't really understand the advantages of selling tokens instead of stocks. But I believe we did cover this, right? The advantages relate, and Ignacio, I think, did speak to that as well, in particular, right, Ignacio?
Right. So I mentioned some of the things such as reduced transaction costs and automated compliance. So theoretically, you can build in a lot of things into the blockchain and cut out some middlemen that would just reduce your everyday costs when it comes to selling and buying the securities. That doesn't mean that in practicality they have all yet to occur. And then this goes back to the other thing that I talked about, where first movers do face a higher barrier. But once that is cleared up, theoretically, there are a lot of advantages to this when it comes to digital assets.
Okay, thank you. Is there a cheat sheet for pre-STO structuring? I'm a small company, very small team looking to do an STO. Well, actually, we are, after this, at the end of the webinar, we're going to distribute our contact information, right, to everyone who signed up. And we will also be offering kind of a guide to how to prepare, for an STO and what are the steps, and basically kind of a cheat sheet of, information and questions that you need to answer. So if you would like to get our guide, please email me. My contact information will be sent to you, but it's an email. It's only 6 letters. Well, actually 9. It's ays@msk.com. Again, ays@msk.com. Please reach out and I'll be happy to send you our guide. Again, my contact information will be sent to you by email as well. Okay, next question. Does this mean that tZERO will do an IEO? And do you have a solid list of interested potential investors?
So I'll let Jor comment on it further, but tZERO does not facilitate ICOs. Our blockchain meets capital markets. Will facilitate a security token offering, but not an ICO.
Yeah, and I want to kind of remind that these comments may be my own, not reflective of tZERO's kind of view on the matter. I'm not sure if tZERO has a kind of firm stance on IEOs, etc. Personally, I think the negative association tied to IEOs has been a association between IEOs and ICOs. it seems interesting to me that if someone could effectively conduct a IPO style of offering through a regulated exchange like NASDAQ, New York Stock Exchange, or the ATS kind of like pro securities, that might be a viable strategy. So, again, those are my own viewpoints. I don't necessarily want to attack the IEOs for what they technically could be. I do realize that a lot of IEOs are problematic if to the extent that they're effectively a continuation of the ICO market.
Interesting. Okay, thank you. Next question is asking us about costs to conduct a token offering. tZERO, you guys, can you share some like approximate estimates of what it takes to take on an issuer and do the kind of the preliminary, the issuance part?
Yeah, for the primary issuance, honestly, it works on a sliding scale. The quotes that are provided are quite customized. We had started off thinking that we'd be able to provide a la carte kind of menu. If you do tokenization, it'll be X dollars. If you do this, it'll be X dollars. But what we've realized is that when people come to us, when people are coming to tZERO, they're coming for a very bespoke kind of process. And sometimes they're asking us to only do tokenization. Sometimes they're asking us to do tokenization and having us put them in touch with pro securities to talk about trading of the tokens in the future. Sometimes they're only talking about consulting, and sometimes they want a funding platform on their own domain versus on the tZERO.com domain. So pricing is honestly variable. I would say that if you're working with tZERO in some sort of issuance capacity, probably it's going to be in the tens of thousands of dollars and up. It could be over $100,000.
Okay, so from the MSK perspective, I can say, again, it's also customized. It depends on what type of exemptions or rules we choose, right, to follow, to comply with. It'll probably start, it'll probably start anywhere from like, I don't know, 25, 30,000, and it can go higher depending on the complexity of your particular offering and whether it's a Reg D, Reg S, or maybe you would like to do a Reg A plus offering. So definitely it'll vary. Okay, next question is more of a request rather than a question. A person is asking to include a glossary, including the various regulations and the timeline for conducting an STO, and on tZERO's website with crystal clear explanations. So this is something for you guys to think about. And as I mentioned, that we will be distributing our guide to the interested parties. So maybe you'll find that to be somewhat helpful. Okay, next question is, will retail investors be able to onboard before that date? I'm not sure what date we're speaking about here.
Yeah, I think I understand what that question is getting at. I think it's for the question is whether effectively non-accredited investors or retail investors could start forming their start establishing accounts so that when and if trading is available to them, they don't have to go through the process of creating an account at that point. And I'll defer to Rob, but I would assume that this would depend on the broker-dealer that you sign up the account with and whether they would allow you to create an account at the moment. To the extent right now it's Dino, I don't know where Dino is in that process.
Right.
Okay.
So again, it'll depend on the timing of when we allow non-accredited investors to onboard. As Jor mentions, it does depend on the broker-dealer, but it also depends on the secondary trading of an asset that a non-accredited investor could trade. So the way we staged it out in January for the platform go live is we allowed the accredited investors to begin onboarding and opening accounts several weeks before trading went live. And we will likely follow a similar pattern for non-accredited investors. As soon as there's an asset that they can trade in, and we know a date when trading will commence on it, a number of weeks prior to that, notice will go out from the respective broker dealers that they will begin onboarding non-accredited accounts. So you'll have a little bit of prior notice and some time to set up your account before the asset starts trading is the point.
Okay, great, thank you. Next question is asking, at what stage does one tokenize when looking to raise capital? For example, seed round, Series A, or Series B. So here I can start answering that as we just mentioned, it is not cheap, right? To to cover the legal. Well, there's going to be the tZERO's costs, the cost of issuance. Then there's going to be some marketing costs. Maybe there's a broker dealer and so on. So, like from my kind of opinion, I would say that you would do like a seed round, at least to get the capital needed to then conduct security token offering. Joe, Rob, what do you think?
I tend to be more flexible here. I think effectively you weigh why you're tokenizing. If you're tokenizing because the benefits of tokenizing outweigh kind of the additional costs, then that's when you tokenize. If you're tokenizing, and if they don't, but there's another reason to tokenize for kind of a marketing effect, or because you want to be tokenized to begin with, so you don't have to deal with kind of tokenize, so you don't have to deal with the consents of tokenizing in the future and going back to your existing shareholder base, then maybe you tokenize now. Certainly there's no pressure to immediately go tokenize now, and even if you don't now, you could tokenize in the future, just making sure that you were able to get the proper corporate consents to do so.
Yes. Okay, next question. What is tZERO going to do to bring investors to the platform?
So Jor hit on it a little bit earlier. Through our routing and execution broker dealer, which is SpeedRoute, we have a network of 150 domestic broker dealers. We're currently in the process of onboarding broker dealers to trade on the Pro Securities ATS. Also, I think there's a real chicken and the egg here, where as you see more assets available to trade, you'll see more investor interest, more accounts open. And then through marketing as allowed under federal laws, depending on the asset and the investors that can hold it, what the marketing rules are around that. tZERO will do marketing as it's permitted to do so.
Okay, great. Next question. What time frames are we looking at for a company deciding to raise capital and get a token issued? And if and it actually being developed, issued on an exchange like tZERO? Will tZERO be able to develop straightforward tokenized solutions off the shelf, or will each company require development of a token? So let's just first talk about just the initial primary issuance of a token. From the moment the company reaches out to you, let's say to us, and through the moment when the token is actually developed and issued, generated, right? So what's the time estimate? Like 3-4 months? Depends, right? Depends on the terms and how quickly the company can come to like a decision as to the terms. Joan,
It could be done quickly, and a lot of, and it depends where someone starts, right? For you've got the legal component, you've got the tech component, you've got the business components, you've got the sales and things like that. If someone was really, really motivated to start, doing a STO and had kind of all the legal paperwork and structuring all done from a technology perspective and just tokenizing and things like that, and getting a funding platform set up and things like that, a couple of weeks would be sufficient. if everyone was firing on all pistons. More realistically, I think give it a couple months would be a safer bet. And much like you're used to, right? Like in the private placement world, if you really had to do a Reg D PPM, you could do it in a week if you had to. But most firms are, especially the big firms, they take months to do them.
Yes, yes. So definitely, I mean, not months for us, but a week would be definitely pushing it. It would be like, it's true, it is a big document. What can you do about it? Okay, so there are two more questions, I believe, and this one is asking about the relationship between Polymath and tZERO, which was announced in early 2018, but I guess has there been any continued conversation over this? Is there any working relationship there?
Sure. So I'll let Jor comment on this as well. But no, we plan on supporting the Polymath ST20 standard for secondary trading at the ATS. So effectively, Polymath and tZERO have a good working relationship. And as the market evolves, they will be an on-ramp for issuances to trade on ProSecurities ATS. And I'll let Jor, add on to that. But there is definitely good working relationship there. It's taken a little bit longer, than we would have liked than we made that announcement, but definitely on good terms with the Polymath team.
Yeah, I probably shouldn't make too many comments on this. I'm in addition to kind of working with tZERO, one of the key advisors for Polymath, and I helped architect and build ST20. But to echo what Rob said, tZERO has publicly announced that it would be supporting the ST20 protocol from Polymath. So you've got really, I have the luxury of working with both teams, and they're both just great teams, and I'm excited that they're working together.
Okay, great. So the last question we have for tZERO, how much of the DTCC friction chain does the tZERO architecture eliminate? Considering that direct peer-to-peer and self-custody aren't really on the near-term roadmap, does DTC/seed and co's role largely remain intact?
So just to be clear, the security tokens that we currently trade on ProSecurities ATS do not settle or clear through the DTCC. So all of the friction is gone. We have worked with, I can't comment on it too much, give away the secret sauce, but we've worked with regulators to establish a different method for settlement of US dollars against security tokens, and it all settles away from the DTCC. So the short answer is all of the friction.
Okay, excellent. So we have no new questions, and we are over time. So I want to thank everyone for logging in to the webinar. I will be distributing our contact information after the webinar to all of you. So if you have any additional questions, please reach out to us or the tZERO team directly. And those who are interested in our guide, please do email me. So thank you so much. Thank you, Rob. Thank you, Jor. Thank you, Ignacio. I think it's been a wonderful and very educational webinar. Thank you.
Thank you. And thank you, everybody, for tuning in.
Okay, bye.